Hi, everyone. Harry here to talk about Donald Trump's efforts to remove his convictions in New York court to federal court. Huh? What? What's going on? Isn't this long since settled? And the answer is not quite. So remember, Trump goes to trial in New York. He's convicted on 34 different counts. It all grows out of the hush money scheme paid to Stormy Daniels in order to prevent her story from coming out toward the end of the election of, we're talking 2016, in a way that they thought would prejudice him. And he fights it in every way and tooth and nail, but unsuccessfully. He has, however, won the election by the time these post-trial proceedings are happening. So what he is still, however, fighting them. Recall that Judge Merchan said, you've been convicted of 34 counts. I'm basically going to sentence you to nothing, but it will be nominal and it will be on the books, as indeed it is, that you are the president, the one president who is serving with 34 felony convictions. That continues to go on, and he continues, Trump, to try to appeal it and wipe out those 34 convictions. And the first thing he has tried to do is, for a second time, remove the case to federal court. That's something you can do. Basically, I know this gets us back into a mindset that we've abandoned in favor of these serious issues of federal law that Trump's actions as president are raising. But basically, the question is, when he did the things he was accused of, was he acting officially in his official capacity as president? Okay, a couple procedural wrinkles. He did not bring this motion in a timely way when he could have. He did it in the middle of trial and it was denied, and now he's doing it again. But in order to do it a second time, you need to have special cause to actually have it be heard, and that doesn't even figure in yet, because what Judge Hellerstein, the federal district court judge that he has first tried this maneuver in front of, remove my case, which is now on appeal, to federal court so I can plead immunity based on the Supreme Court's decision in Trump. And Hellerstein said, look, you've got a very high burden here, but it doesn't even matter. I've said this before, and indeed he has. And Trump didn't appeal it before in a timely way, so it's already settled against him. But the main thing is, we are talking about hush money paid to a porn star by a non-president, a candidate, in order to keep it from coming out. Candidates are not the president. This is in no way an official act. Goodbye. And so where we are today, hang with me, it's not all that complicated once we remember the original case. He's in front of the Second Circuit, which is the court above Judge Hellerstein, and he's going to try to say Judge Hellerstein's opinion below, where he said it's a second notice and you can't do it, but also forget about it. He loses on the merits, as I've already held. This is in no way acts in his official capacity. So the Trump case, nothing changes this. That's what he's going to try to argue to the Second Circuit. Oh, and he's got a new support here, and guess who that might be? The United States Department of Justice, which is coming in on his side, even though in both the rulings about it's not timely and on the merits, there's just really, no argument at all. And it's a more of a demonstration that the Department of Justice has been changed into the personal lawyers of Donald Trump. But so he now goes to the Second Circuit and he says, change what Hellerstein said, let me go and let me remove my case from state court, where it now is being appealed to the appellate division and the Court of Appeals, the highest court of New York. Instead, bring it in federal court, and I like my chances better there. It doesn't change, in theory, the substance of the case, but I like my chances better there to make my immunity arguments, and that's why under the immunity statute I should have the ability to go. But you have to make a certain showing, even if it were the first time, and it's not. You have to make a much higher showing if it's the second time. And Hellerstein, in a short but forceful order, says, get out of here. You can't possibly make this showing. This is conduct that you were convicted of that has really no possible connection to your official federal duties. So that's what the Second Circuit will consider. I don't think they will reverse Judge Hellerstein, in which case back up to the Supreme Court. I think for now, rather than having to rememorize the whole kind of setting of state court, it's good enough to just remember, oh yeah, he's still fighting his convictions. He still wants to remove this scarlet letter that has him as the one president who has ever been convicted of crimes. Right now, he assails it politically and tries to say Mayor Chun was biased. That's one of the reasons, by the way, he's claiming now that he can get past the normal bar and bring it up again because Mayor Chun was biased. Remember that has to do with Mayor Chun's daughter working in some firm that does work for Democrats. Really a very weak claim. Anyway, he's trotting out everything that we've already heard and the courts have already settled. And this one basically turns on is the official or unofficial status of his conduct as charged in the indictment and what he was convicted of. There's a little bit that happens after he's president when the story comes out in the Wall Street Journal. Remember all these old chestnuts? And Hope Hicks talks to him about it. Again, I don't think we have to go into in depth. The basic ruling below is, no, it's your second time, but even if it weren't, no chance for removing to federal court because there's no even tenable claim that what the conduct here you're charged with is deserving of immunity. So stay with the New York courts, take your claims on the merits about the appeal, whatever you want to say, to the appellate division, then the New York Court of Appeals. Just one final point. There were lots of arguments, you'll recall before, about whether or not Trump would have been convicted had the DOJ moved more quickly. I generally had a minority position there, and I don't want to, we have enough controversy on our hands here. But one of the big things I said is there was never a world in which, even if the Department of Justice had started a year prior, it would have gone to conviction. And this is part of what I'm talking about. We're now, months into his presidency, and he's just doing still a procedural motion in the federal court, hasn't even come on the merits of the appeal. A conviction's not final until it goes all the way to the top of the state court and the Supreme Court. It's just another way of demonstrating this. He was going to be able to run out the clock even had the clock started sooner. Talk to you later.
Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.